Hello, everybody. It's Walter, your favorite historian, educator, professor, social studies extraordinaire, and blue-collar scholar. Thanks for tuning in today. Today's date is September 30th, 2025. This video is entitled The Judiciary Act of 1789. The Judiciary Act of 1789 is one of the most important federal laws ever enacted. This law, which was enacted by the very first United States Congress assembled in New York, New York, this act, signed into law by President George Washington on September the 24th, 1789, established the federal court system in America. The Judiciary Act of 1789 created a three-tiered federal court system, with the Supreme Court of the United States at the top, U.S. Circuit Courts below them, and United States District Courts at the very bottom. The Supreme Court itself is established by Article 3, Section 1 of the United States Constitution. But the framers allowed Congress to worry about the particulars, such as how many justices it would have, where it would sit, and so forth and so on. In the Judiciary Act of 1789, Congress established a Supreme Court consisting of 6 justices, one of whom would be the Chief Justice. The court's original jurisdiction is established in the Constitution as well. And similarly, in Article 3, Congress has the power to establish and outline the Supreme Court's appellate jurisdiction, which it does very well in the Judiciary Act of 1789, and has also expanded and reduced that jurisdiction through subsequent judiciary acts through time. Under the Supreme Court, the United States Circuit Courts were established. These were the original major trial courts of general jurisdiction of the U.S. federal government. All right, and they had jurisdiction over most types of issues, legal issues arising under the Constitution and laws of the United States. All right, and for more than a century, these were the primary trial courts of the United States federal government, handling most types of federal jurisdiction before it arrived at the Supreme Court. And beneath the U.S. Circuit Courts were the U.S. District Courts. Now, originally, the U.S. District Courts were trial courts of very limited jurisdiction, primarily handling matters of admiralty and other maybe perhaps small crimes, small civil matters. But in any case, most federal jurisdiction at the original jurisdiction level was to be handled by the U.S. Circuit Courts, not the U.S. District Courts, which is, of course, completely the opposite today. Now, fast forward 230 years, we more or less still have this original structure in place, with the Supreme Court at the very top. Instead of U.S. Circuit Courts now, you have the U.S. Courts of Appeals, which are now exclusively appellate courts. They have no trial jurisdiction whatsoever. And beneath them, you have the U.S. District Courts, which are now the primary trial courts of the U.S. federal government and have broad, very broad and expansive jurisdiction to hear virtually all types of cases and controversies arising under the Constitution and all other federal laws. Okay, so from it all, you see that from the Judiciary Act of 1789, we still pretty much have the same general structure that Congress established some 236 years ago for our federal court system. Not much has significantly changed. Of course, the federal judiciary has been augmented in both size and jurisdiction since 1789, but you still got the same basic structure, a three-tiered federal court system that was established under that original Judiciary Act. All right. With the Judiciary Act of 1789, you also have the support system for the federal courts established as well. You have U.S. attorneys, the offices of U.S. attorneys in each of those jurisdictions. You have marshals, okay, you have clerk's offices, obviously all necessary for a fully functioning court system. A unique feature of the Judiciary Act of 1789 was a section which enhanced the Supreme Court's original jurisdiction to allow it to be able to issue writs of mandamus, which of course was the primary subject in the landmark case Marbury versus Madison in 1803, in which the court found that Congress had unconstitutionally expanded the court's original jurisdiction when that jurisdiction itself is already outlined in the Constitution. So Congress didn't have the power to adjust the court's jurisdiction from what's already in the Constitution outside of a constitutional amendment. Okay, so that act is what got the federal courts going, ladies and gentlemen, and make no mistake about it. The vast majority of litigation in the country, both then and now, still took place in the state court systems, not the federal court system. All right, and originally in the Judiciary Act, the federal jurisdiction was very limited. Federal courts were very limited in what they could hear. All right, Congress had the power to establish a federal court system below the Supreme Court, also via Article 3, Section 1 of the Constitution, and it did so accordingly in creating the U.S. Circuit Courts and the U.S. District Courts. All right, now again, as I say today, the U.S. District Courts are the primary trial courts of the federal government, handling most entry-level federal jurisdiction, having jurisdiction over virtually all cases and controversies arising under the U.S. Constitution and other federal laws. Okay, above them you have the U.S. Courts of Appeals, which are exclusively appellate in their jurisdiction, and finally at the top, of course, the Supreme Court of the United States, which more or less 98% of the cases it hears under its appellate jurisdiction. And the court, believe it or not, Supreme Court does indeed have original jurisdiction to hear cases as outlined in the Constitution, but in order to have your case heard under its original jurisdiction, it must meet specific criteria. All right, so the Supreme Court hears very, very few cases under its original jurisdiction. Okay, typically disputes between states, all right, and other very limited matters. Okay, can you go right to the Supreme Court? Virtually all of its other jurisdiction is appellate. Okay, so that is the Judiciary Act of 1789, an act that has truly stood the test of time. Okay, and it of course has been supplemented by further judiciary acts throughout time to reflect the needs of an ever-growing nation with varying types of legal issues in demand. Okay, but I'd love to hear your thoughts on it, and I know you've learned a thing or two from this video, I'm sure. Leave them in the comments down below, and I'll be happy to engage in peaceful civil dialogue and discussion with you. So I want you to take care of yourselves, stay safe out there, and I'll talk to you at the next video. And before you leave, if you haven't already done so, please like this video and subscribe to my channel. I'd greatly appreciate it. Take care of yourself, stay safe out there. Talk to you at the next one. Professor Shelton, the Blue Collar Scholar, out.